Welcome everybody to another US Inventor Zoom meeting. To start off, as usual, I always like to restate our mission, because the mission of US Inventor is extremely important. Our mission is to restore to inventors and patent-based startups the ability to stop infringers from simply taking what you have invented and patented. It was never easy to stop an infringer, especially a large infringer, but it has become virtually impossible today with what has happened to our patent system. And we're fighting hard to get legislation that will restore our rights, and we're fighting on many fronts, and really appreciate the support of all of you out there. Now, today, we have a very well-known guest, someone who's kind of famous among people who've been in this space for a while. We have former Chief Judge Randall Rader. Mr. Rader was served on the U.S. Court of Appeals for 24 years and has been very active. In fact, he's kind of famous for what he referred to the PTAB as. And if I have you can correct me, Judge Rader, if I get the wording wrong, but I believe you were quoted as calling it a death squad for patent rights. And but anyway, I'm going to go ahead and introduce former Chief Judge Randall Rader. You've got the floor.
Okay, thank you very much, Randy, and it's an honor to be here amongst inventors, the embodiment of our nation's and the economy's future. Now, for more than 30 years, I've taught patent law, and I kind of took I've just started it's probably my 31st class at George Washington University. I also teach at Tsinghua University in China, but that won't start till next week. And it's digital, as you might imagine at this point. But I kind of am taking as my theme today a little bit of the history of the patent system and how the patent system has really been developed and grown through the actions of intellectual property heroes. These were great, insightful leaders who saw the need and changed the law as necessary to achieve the great stimulus for invention, prosperity, and innovation that our patent system has become. So let me start by saying we're at a time when we vastly need more heroes, and that will be the theme that I'm going to try and sound, that we need heroes like the people I'm going to be speaking of in summary fashion today to give you an overview of the kind of hero we should be looking for and where we should be looking for them. My first hero nominee is a tandem of individuals, a Virginian named James Madison and a South Carolinian named Pierce Butler, who in 1787 perceived a difficulty with innovation and economic system because each colony had its own separate invention system, and they were in collision and colliding with each other. And I've read many accounts of New York giving patents on steam technology to one individual while New Jersey gave them to another. Pierce Butler came up with the idea that maybe we should incorporate the patent system, a system of giving an exclusive right as an incentive to invent and disclose. This was adopted by James Madison and included in the Constitution. Now, this is the first Constitution in human history. The Magna Carta is not really a constitution, and it was toothless, as you may all understand, but This is the Constitution that set off the revolution in human rights. And right there in Article 1, Section 8, Paragraph 8, is the protection for discoveries in the useful arts. Our legislative heroes. And by the way, I'm going to extend a special salute to James Madison, who takes his talents from the Constitutional Convention to the First Congress, where in 1790, the first Patent Act is adopted. This is before we have a Bill of Rights, by the way. And the heart of that Patent Act is adopted. It's again authored by James Madison. What a legislative hero of intellectual property. I'm going to jump forward a little bit and mention our next hero of intellectual property. Joseph Story was his name. He was a Harvard law professor who became a Supreme Court justice. He continued, however, when rotating through the circuits, as they did in those days, he continued to hear patent cases, and in many of those, he corrected important problems. For instance, at that time, it was a first to invent system. It only made sense if you invented something to not disclose it or to delay the disclosure, because you had the evidence that you were first to invent. Let somebody else work out the kinks, develop the market, and then you could come in with a later disclosure, obtain your patent. Joseph Story, recognizing this problem, created the statutory bar as a way to correct this and ensure that you had to make an early disclosure or risk losing all of your inventor rights. My next hero of intellectual property is another judge. We have tended to forget his name, but in my era of law school, he was still heralded as one of the giants of intellectual property and American jurisprudence in general, Learned Hand. We forget how Learned Hand really earned his reputation in New York doing patent law. And he was the one who called the lack of an obviousness standard. Remember, this is before Section 103. And we had something vaguely called the invention standard, in which judges would look at the invention and try and guess if it reflected a flash of genius or if it incorporated some kind of synergism. The 103 test, as we know, requires you to forget the invention, go back to a time before its creation, and ascertain if an inventor would have made this critical step forward. Well, Learned Hand was instrumental in calling this unfunctional and deleterious lack of a standard to identify true invention as a palpable phantom. He called it the greatest phantom of American jurisprudence. And that leads perhaps to the work of some of my next hero of intellectual property, Giles Rich, patent attorney from New York, helps devise a workable standard for invention that doesn't look at the invention and get some kind of guess as to whether it's inventive enough, whatever that means, but instead looks for real prior art and real evidence that creation of 103 still didn't correct the errors of the Supreme Court, which continued to pursue a faulty invention standard for many years, and leads to my next group of heroes. I'm going to select 3 out of several, but Orrin Hatch, Ted Kennedy, and Bob Dole were instrumental in creating the Federal Circuit as a way to deal with this lack of an invention standard. The patent law was so undefined and diffuse, and well, it was that phantom that Learned Hand talked about. The idea was to create the Federal Circuit to provide strength and uniformity. And those great legislators made that happen. I'm going to come back to another great visitation of one of the names we've already mentioned, and I'm going to mention Orrin Hatch again as a great hero of intellectual property. He saw that, particularly in the area of pharmaceutical patents, the conflict with the regulatory system meant that a patent owner would not get access to enforceable patent rights until 8, 9, 10 years into the term of his patent, meaning that he didn't even have an opportunity to recover the full costs of his research and development. And so Orrin Hatch, again, a legislative hero of intellectual property, stepped forward and proposed patent term extensions. He hoped they would be more, but at least you can get 5 years added to the term of your patent when it's encumbered by slow patent office procedures or regulatory delays at the Food and Drug Administration. Well, I've mentioned a few of these heroes: Madison, Butler, Story, Learned Hand, Orrin Hatch, Giles Rich. I think it behooves us to think of what heroes are needed for today and why they're needed. And the reason they're needed is because the system is in more distress than it has been since that time of the palpable phantom that Learned Hand talked about. And in fact, it's exactly the same problem. You have this palpable phantom of judges looking at the invention and deciding if it is eligible for patent protection, because even they don't even look at the prior art anymore. They just look at it and, well, does it add enough to the inventive world to deserve a patent? What does that mean? It means absolutely nothing. You can't determine if something adds enough, if it's significantly enhanced, without understanding the prior art. And so you have this rebirth of the invention problem that required the heroic activities of Learned Hand, Giles Rich, and the legislators that I mentioned, including Orrin Hatch, to try and correct that problem. And that problem persists today under 101. That's not the only problem. To that, we have to add the confusion over the disclosure standards in 112. Again, the problem comes for largely the same reason. The courts have abandoned the statute. They don't look at the statute and exactly what it means, and they have created their own series of tests that are not supported by the statute, just as 101 certainly doesn't justify the kind of search for additions to an inventive concept. The exceptions to the statute have swallowed the statutory rule in 101, and the same thing's happening in 112. Another area of great need is remedies. There's a basic remedy for trespass on property rights. If someone is camping in your backyard, that trespass is easily remedied by removing the trespasser. Well, that is complicated by the way the courts handle the property rights granted by the Patent Act, because you have to prove that there's a reason to remove the inventor, the trespasser. Well, that's kind of, this is the eBay case that came again out of a hostile Supreme Court that didn't grasp the reason for the statutory language. Let me just visit this one very quickly. The Supreme Court says, well, you have to prove that there's a reason to remove the trespasser because the statute says the court may enforce an injunction after a finding of infringement. Well, there's a reason that the statute said may. It said may because it had to protect the public safety. Classic example, I do this in my patent law class every year. I say, okay, the invention is a pacemaker for your heart, and it infringes. Shall we enforce an injunction and remove the pacemaker? Of course not. The statute had to say may, so that if it's necessary to protect public safety. Another example, by the way, is a wastewater treatment plant. It infringes. You're not going to turn off the wastewater treatment and endanger public safety. The statute had to say may for that reason. In every other instance, the remedy should be remove the trespasser. That's another need for heroes. And finally, I'll revisit an area familiar to all of you, and that's the Patent Trial and Appeal Board, which I did label a death squad, and it's fulfilled my predictions. At that time, it hadn't barely gotten started, and I was just predicting that it would be a death squad, but it wasn't hard to make that prediction. You give 300 people the title of judge and tell them their job is to invalidate patents. What are they going to do? Well, they're going to do what they have done, and that is to be a death squad for patents and patent rights. All of this is just to lead up to the theme I announced at the beginning. We need new heroes. Those heroes are probably going to be necessary in the mold of Orrin Hatch rather than of any judges. I don't see any judges in our current system that are of the stature of Giles Rich and capable of calling forth and identifying the problems clear enough for the Supreme Court to deal with them. That's what another famous activity of Giles Rich. He would write dissent after dissent about how the invention standard was not working. And eventually the Supreme Court awoke. And I note often that we have not got any Giles Riches. There have been very few dissents. There could be hundreds, and there have been a handful. And the Supreme Court, for that reason, thinks, well, the system must be okay. And it goes on doing its damage to innovation and inventors. Well, I thank you for the chance to address you today. I urge us to think about the need for real heroes in intellectual property. I urge us to think of the value that the system has brought to us over the years, elevating our economy as it did, saving our economy at the outset of our republic. Inventions are probably the reason that our republic survived those first decades of instability. And they will be the hope of the future for our children's generations as well. But we have a good deal of work to restore the patent system to its proper role. I hope that listening today are some heroes of IP that'll step forward like Joseph Story, Orrin Hatch, Giles Rich, and help us make the patent system great again. Thank you.
Well, thank you for that. That was very inspirational, and I want to ask you. So
Sure.
there's one Supreme Court justice who always writes a great dissent when the Supreme Court makes a terrible decision on our
Gorsuch.
Yeah, yeah.
And he may be our hope. He may be our potential hero, but he's on a court where he's got to have 4 other votes.
Right.
Now, in theory, that could happen. He's acquired there at the time he came in. We got Justice Barrett, Justice Kavanaugh. In theory, Justice Thomas and Justice Roberts and Justice Alito proclaim their allegiance to statutory language. Let's go back to the statute on eligibility. Let's go back to the statute on enforceability and injunctions. Let's go back to the statute on 112. And if Gorsuch might be the one to help us get there. You're right. Our potential hero may be there. Sadly, as I said, the Federal Circuit, the court that should be identifying problems, is instead doing exactly the opposite and perpetuating them.
Yeah.
But thank you, Randy, for recognizing I too would identify a potential hero. They have to act before they get any heroism medals. You don't get medals for sitting in the foxhole. You got to get out and do something.
Right.
Ron Katznelson has his hand up.
Yes, Ron.
Thank you, Chief Judge Rader. Appreciate your participating in our call.
Thank you.
It's a refreshing opportunity to talk to you again.
Thank you.
Two questions. One brief on the issue of the coinage of the term death squads. You just indicated it was a prediction. It was in May of 2013 at the AIPLA, in which you said it. There are hardly
Response
13.
to a question from Q. Todd Dickinson, the late Q. Todd, who was at that time AIPLA's executive director.
Yeah, and APJs have criticized you, but look, he was saying this before even seeing what the results are, not understanding these are projections. But isn't it true that you received from the PTO, based on a request to give a plan or their projection of the number of cases they expect to see? Didn't you see some numbers that they produced?
Yes, Ron, you remember that so well. Dave
Capos?
Capos, my dear friend, was the head of the director of the patent office at that time, and I anticipated that the PTAB would generate a good deal of activity. And so I wrote to him in an official sense saying, I need to have an official estimate so I can go to Congress and ask for resources to be prepared for what I saw as a potential tsunami of cases. By the way, some of my colleagues at that time really mocked that term, and today they wish they'd listened. 70% of their work comes from the PTAB. They hate it. They wish they had had the foresight to see the problem coming. But the number that Dave Capos sent back to me was a bit ironic, and Dave and I both laugh at it on occasion. He said, well, at most, it would be 500 cases a year. He says that's a very high estimate. Of course, we all know that it's thousands of cases a year, and that it has been the tsunami in the way that patent cases are now adjudicated. The district courts, which at that time were hearing around 6,000 patent cases a year and dealing very credibly with validity as well as infringement, are now down to less than 3,000.
In that projection that he gave you,
Yeah.
did he break down his estimates of cases that would be petitioned versus decisions to institute and final written decision coming out?
Yeah, no, he was talking about petitions, people coming to the system at the front end, of which a certain amount would have been weeded out early with the refusal to initiate the proceeding. That's what he was talking about. And he thought 500 was too high, but he was going to throw out a high number because he knew that I was trying to get resources to deal with the potential tsunami. Turns out the tsunami was much greater, and it's kind of overtaken the system now.
Yeah. Second question is on the issue of injunctions or the real solution for preventing infringement. You attribute some of the problem to the courts, but isn't the problem really the statute back in the 1800s when in fact Congress resorted to equity as a means of enforcing patent right, where equity inherently requires the balancing of equities, including balancing the hardships between the parties.
This is the way it's been since the outset of the system in England, and the remedy of injunction is an equitable remedy, but that doesn't mean that it's somehow a balancing exercise. No, it was very clear that it's there. This is the mistake the Supreme Court made. They said, oh, it's equity, so we've got to balance all these factors, and you're going to have to prove to me that you really deserve. No, the courts had recognized, going back to the mother country origins, that the remedy for violation of property rights was to remove the trespasser. Now, they needed to have the equity for the reason I just told you, health and safety of the public. There would
Right.
be instances that everyone could anticipate where, well, if the in question is infringement of vaccines for pandemics, we're not going to pull the vaccines off the shelf because they infringe.
But wouldn't a solution like the exclusion order of the ITC be a better statutory framework where specific factors related to the public interest are enumerated in the statute, and there's no room for involving equitable balancing and actually have something that is exclusion order? Let Article 3 court have the right to have exclusion orders.
Well, I am happy with the way the ITC works. The ITC has been a wonderful remedy. It has been aggrandized due to the failure of the Article 3 courts to understand the proper role of equity in the enforcement system for patents. But no, this system worked just fine for not just the 200 years of the United States, but the 400 years going back to 1624, when the statute of monopolies really gave birth to the modern patent system in England. And it was, yes, the remedy was equitable, but it was a understood, solid system. Justice Roberts, Chief Justice Roberts, writing a concurrence in the eBay decision, quoted from Holmes and said, a page of history is worth a volume of logic. And what he was saying is, for 400 years, we've removed the trespasser. I expect that history will continue. Instead, the Kennedy concurrence has prevailed, and he said, oh no, there's people out there who misuse the patent system. And so what do the courts do now? Well, they apply a different standard for some people than other people. You never do that in a judicial system. You don't measure remedies according to the characteristics of the parties. You don't look and say, well, this party's a big one and that one's a small one, so we're going to favor this one over that one, or this one is a practicing entity and that's a non-practicing entity, so we're going to favor this one over that. You don't look at the characteristic of the parties to give remedies. But
given that the court has done that, isn't it our only option to go back to Congress and say, okay, the Supreme Court insists on some balancing. Can we just ask you, the congressman, to just write the statute just like you wrote the statute for the ITC, and that's for every Article 3 court now?
I hear you, and that could work. No, I like the 400 years of history, and I'll stick with the page of history over the volume of logic. And, you know, we've only had a decade and a half or so of confusion after eBay, and it is appalling the way it operates. We can correct this, and correct it we should.
Thank you.
Yeah, sure.
Well, one of our, go ahead, Joel. Yeah.
Thank you. Thank you, Judge Rader. I wanted to maybe incorporate some of the comments that the questions I've seen in the chat too to this. But first, I never dug far back into your education, and then I realized that, like me, you were an English major, but you were not an engineer or someone with a science background. So like me, you can't take the patent bar. And that gave me a lot of encouragement. One of the things that was asked in the chat was whether you could give advice how to get stronger or more protective or more comprehensive or better patents. I don't know if you share this view, but one of the things that I've said to clients in the past is that sometimes folks who don't have an English background may not pay attention as much to the use of language as an effective tool to provide more comprehensive coverage for patent claims. I'm not sure if you have a view on that.
Well, I teach the philosophy of language a little bit in my patent law class, pointing out that there is inherent in any expression ambiguities and what the great Cambridge professor Wittgenstein called the social influence of any language. And we don't really understand fully each other because we have a different background wherein we learned the language. Yes, all of that's true, but we still can, with an immersion in the prior art and in the publications and patents that precede, we can come up with language which does define and which can be interpreted to give proper boundaries that fence around the intellectual property that it is a difficult task. That's why I train these kids in my class how to draft patents. And we do one class where we draft the patent and then we tear apart their draft and show them how difficult it is. But it can be done. And that's why we have patent lawyers. That's why we should have courts with the capability to honor what those patent attorneys and patent examiners have jointly agreed upon. Now, I'll make one quick comment. We often hear about the need for quality patents. If a patent issues, it has quality. Now, it'll be attacked by the infringers as not having enough quality, and they will attack it as not having enough precision. There is always some degree of imprecision, but there is also an ability to provide proper boundaries and proper enforcement of those boundaries to ensure the patent system works. It did work for hundreds of years, and it's only in the last couple decades that we seem to have lost that confidence. And actually, that loss came in the form of large corporations who wished to profit from the work of other inventors and to use their work without compensation. And they want to do all the inventing themselves. And the world doesn't work that way.
Let me ask you a quick follow-up.
Sure.
Goes to another question that was in the chat. So someone asked, why would judge professor go to teach patents in China? I'm actually going next week. I'm going to be in Colombia in Medellin, and I'm teaching a class at the law school there. And I've been to China, and I've met with the dean at the law school in Shanghai. And one of the things that I came back with was a real appreciation, and this is a little nerdy, but for the difference between, and perhaps in some cases, the advantages of a civil law system, where instead of the opportunities for judges to get things wrong like they did in eBay, where there's a clear set of rules that that are followed, and without insulting the books behind you, even though I think they're virtual, there's none of this playing around with the authorities to come out with a result that's preordained. What about that? Is the use of the civil law system to decide patent disputes and determine validity of patents in other countries that follow it, is that perhaps a better way? Is there more certainty? Is there more reliability for folks who are listening, who are US inventors, but who may also be applying for protection in other countries? Are they getting better justice there?
Well, it's a complex question. I can tell you, I teach abroad because the world, the patents know no boundaries, and technology knows no boundaries, and it needs to be enforced in Asia and Europe as well as here. Do they do it better there than here? You could make a pretty good argument that our system is the one that has the most flaws in it, but our system is also the most compensatory. We have the best damages. We take care and give the best value to intellectual property once we determine it's been infringed. So there are strengths in each system. I could spend and do with my clients often spend a good deal of time educating them on the virtues of various systems and how you can use one system to assist another. But I commend the quickness and efficiency of the German courts. I commend a good deal about other systems, but I don't sell ours short either. While we're out of step, particularly in the areas that I mentioned, eligibility, proper remedies under injunctions, there is still reason to look for the heroes that'll make our system great again.
Thank you.
Speaking of which, I've got a question here from Jeffrey Snover. How is it that we can step up and be heroes? What do you recommend?
Well, part of that's going to be legislative, and we're going to have to throw proper support behind actions which will reform 101 and get it back into the, actually it doesn't really need to be rewritten. Maybe we need to add a little phrase at the end of 101. And this time we mean it. Just follow the statute. But part of the work's going to have to be that. Frankly, we need better judicial work. There's going to need to be some reforms made in that area. And it's my hope, as suggested earlier, that maybe we have a few heroes lurking in the background, like Justice Gorsuch.
So for the members here to be heroes, I would think that visiting Congress, visiting their congressmen, attending town hall meetings, writing letters in any way possible, making a case as clear and simple as possible are all ways in which they can do it. Do you think that those are effective?
Yes, and sometimes you don't even need to pass the law to have the impact. I tell this story often. I was working in Congress for the late Orrin Hatch when we started to pass the Court Improvements Act, which led to the creation of the Federal Circuit. Seeing that was about to happen, the Supreme Court had corrective work in their jurisprudence. The Deere opinion and the Chakrabarty opinion both came down on the eve of the passage of the Federal Circuit. The Supreme Court was trying to say, hey, look, we can do it. We can do it. You don't have to pass, create a new court. We'll do the patent law right. So sometimes the threat itself might be enough to inspire the proper reform.
That brings another question. How sensitive are the courts to embarrassment and criticism? It seems to me that judges sit on high benches because the illusion of power is very important. But when they make radically stupid mistakes like they have been with Alice and a number of other eBay and a number of other areas,
there's no court that's invalidated patents at a higher rate than the Federal Circuit. The court created to protect patent rights.
Is it effective to attack the court? That's what I'm trying to figure out. Will they respond?
Well, there are proper ways to do that. And, just a couple weeks ago, the chief judge there extended deadlines beyond imagination to allow Judge O'Malley to retire, then appointed a new panel and changed the result by appointing a new panel member. That sort of activity ought to be, reflects very poorly on the judicial system. And yes, you need to say so.
Where would saying so have the biggest effect on?
Well, the first way to do that is through the judicial procedures themselves. You look for petitions to reconsider, petitions to take en banc. But, all of our institutions, including US Inventor, and I've been saddened that since Q. Todd Dickinson left, AIPLA has not been a very stalwart voice in protecting IP rights, but all of those institutions need to step up. The intellectual property section of the ABA, all of them need to say, look, some things that we've observed are not in harmony with the statute or that page of history, which should outweigh a volume of logic.
Well, all right. Well, I had one more question from Mike Doyle was asking, what are the chances, in your opinion?
Tell Mike hi.
Okay.
He's a dear friend, and we used to play basketball together.
Okay. His question was, what are the chances that 101 will be fixed in the next 5 years? The 101 problem.
I don't expect it to be fixed. I expect us to make gradual progress to a point where we can, and the gradual progress comes through the courts, and sadly the Federal Circuit's not a very promising institution for that, so we may have to look to the Supreme Court. But if we can continue to petition the Supreme Court to take a 101 case, eventually they're going to realize that there's some problem if we keep hearing about it. And that would be a step in the right direction.
Well, Judge Rader, thank you for your time. I know we held you longer than you expected, so thank you so much.
Well, I'm glad to be with you.
Yeah.
Thank you. And you have a role to play here. I hope you guys will be one of the heroes out there.
Well, we're working at it. Thank you.